Research is to see what everybody else has seen and to think what nobody else has thought. A very warm good morning to one and all present here. Today, we're all gathered here on this virtual platform for the 16th two-day national workshop on research methodology put forward by the Kerala Law Academy Law College Trivandrum in association with Center for Advanced Legal Studies and Research. I proudly welcome each one of you to this event. Kerala Law Academy Law College, established in 1966 by the legal luminary late Dr. N. Narayan Nair Sir, is a seat of excellence in legal education, consultancy, research, and pioneering law reforms. Kerala Law Academy Law College is always in its constant effort of pioneering novel ideas and is in the path of deliberation to provide the best stimulating experience to the students to harbor and bring out the polished versions of their talents and skills through its various programs and events of national and international importance. Organizing workshops as a part of legal education is part of one such venture. Before we begin our session, let's spend a minute in silence to cherish the memory of our beloved Narayan Nair Sir. Thank you all. Research provides us new domain of knowledge, new theories and laws, solution to a problem and opens new areas of thoughts. Further, it has the potential to question and analyze the existing theories in accordance to the present circumstances. Hence, it is necessary for educational professionals to be acquainted with the process of research, that is, research methodology. It is worth to mention that research is a systematic process and the knowledge of research methodology helps for a better understanding to pave way for a solution. Therefore, it is very much important for a researcher to know all the aspects and steps of research process in order to make it systematic. This workshop on research methodology will make the young researchers familiar with the various aspects, tools, and steps of conducting research. Today, we are blessed with the presence of eminent personalities and academicians. So, I invite Professor Dr. N.K. Jayakumar Sir, former Vice Chancellor of National University of Advanced Legal Studies, Kochi, and member of Executive Committee of Kerala Law Academy Law College. Advocate Nagaraj Narayan Sir, Director of Kerala Law Academy Law College and member of Bar Council of Kerala. Professor Harindran K, Principal of Kerala Law Academy Law College. Professor K. Anil Kumar, Senior Faculty Director of Students Relations, Kerala Law Academy Law College. And I invite all our beloved teachers, participants, faculty conveners, and student conveners to the 16th two-day National Workshop on Research Methodology. A good teacher can inspire hope, ignite imaginations, and instill a love for learning. Mr. G. Anil Kumar Sir, Professor, Kerala Law Academy Law College, is a living example of this statement. Sir joined this prestigious institution in the year 1998, and with an experience of over 24 years, he has proved himself to be a selfless teacher. With immense pleasure and gratitude, I welcome Professor G. Anil Kumar Sir, and I also take this opportunity to invite him to officially welcome our guest into the session. Anil Sir, please.
Thank you, Kavya. Good morning to one and all. Respected Dr. N.K. Jayakumar Sir, former Vice Chancellor in UWorlds, Advocate Nagaraj Narayan Sir, Director Kerala Law Academy, Professor Harindran K, Principal Kerala Law Academy, Professor Anil Kumar K, Professor Kerala Law Academy, and other distinguished invitees, my colleagues, and dear students. A warm welcome to one and all. It's a matter of pride and privilege to welcome the legal dignitaries who have gathered here to take part in the 16th two-day National Workshop on Research Methodology put forward by Kerala Law Academy Law College, which is scheduled on 14th and 15th of March 2022. This is an effort to enrich the research scholars in law on research methodology, focusing on theoretical and practical inputs. Primary focus of this workshop is to improve research quality, create an environment and culture for the research, The 2-day workshop will consist of all the components required in a research cycle. Now I move on to the duty entrusted upon me, the formal welcome address. Today, we are indeed blessed to have the presence of Dr. N.K. Jayakumar sir, former Vice Chancellor Newalls, Kochi, and member Executive Committee, Kerala Law Academy. Sir is an eminent jurist and academician who took his LLB, LLM, and PhD from Kerala Law Academy Law College. He was the professor, head, and dean, Faculty of Law, University of Kerala, and had served as the Secretary, Kerala Legislative Assembly. Further, he had served as the Vice Chancellor, National University of Advanced Legal Studies, Kochi, and National Fellow, Indian Council of Social Science Research, and also the Special Advisor to the Government of Kerala. I, on behalf of everyone present here, welcome Dr. N.K. Jayakumar sir to this function. Today, he will be conversing with us on the topic Introduction to Research and Selection of Topics. Now we have Advocate Nagaraj Narayan sir, Director, Kerala Law Academy, Special Government Pleader Forest, High Court of Kerala, Member Bar Council of Kerala. It is my pleasure to invite Advocate Nagaraj Narayan sir to this function. Our principal, Professor Harindran K. sir, is a source of inspiration for us in all the activities that are conducted within the institution. From the bottom of my heart, I extend a warm welcome to Professor Harindran K. sir to this function. Now, I would like to invite Professor Anil Kumar K. sir, Professor Kerala Law Academy, who is a constant source of support and motivation. I heartily welcome Professor Anil Kumar K. sir to this function. Last but not the least, I would like to welcome all the faculties, students, teaching, non-teaching, and administrative staff to this function. Thank you.
So thank you so much for your valuable words. Now I welcome Mr. Aditya Jayadev, student of First Sem LLM from Kerala Law Academy Law College, to welcome Dr. N.K. Jayakumar sir.
A warm greeting to this August gathering. Today, we have gathered here on this virtual platform as part of 16th two-day National Workshop on Research Methodology, organized by Kerala Law Academy Law College in association with Center for Advanced Legal Studies and Research. This two-day National Workshop aims to improve the research skills and competency among the researchers by strengthening their knowledge as well as improving researchers' technical writing skill, paper writing, and writing research proposals. This national workshop on research methodology will make the young researchers familiar with the various aspects, tools, and steps of conducting a research. The topic of this session is Introduction to Research and Selection of Topics. This session is chaired by Professor Dr. N.K. Jayakumar sir, who is an eminent jurist and academician. He took his LLB, LLM, and PhD from Kerala Law Academy Law College. He was the professor, head and dean, Faculty of Law of University of Kerala, and had served as the secretary to the Kerala Legislative Assembly. Further, he had served as the Vice Chancellor of National University of Advanced Legal Studies, Kochi, and has been a National Fellow of Indian Council of Social Science Research. Currently, he is serving as the law advisor to the Chief Minister of Kerala. He has published 11 books, many research articles, and articles on current issue. He has served as a visiting professor in many universities in India and abroad. Sir, it is truly an honor for gracing this occasion with your benign presence amidst your busy schedule. It is a privilege to have such a distinguished personality on this occasion. With immense respect and pleasure, I invite you, sir, to enlighten us on Introduction to Research and Selection of Topics. Sir, please.
Good morning. First of all, I must. Can you hear me now?
Yes, sir.
Yes, thank you. First of all, I would like to say a word of thanks to the students, Kavya, Mohan, and Aditya, and also Professor G. Anil Kumar for the kind words of introduction spoken about me, using a lot of superlatives, but I'm sure I don't deserve all those superlatives. Now, this is the 16th edition of the National Workshop on Research Methodology organized by the Kerala Law Academy and the Center for Advanced Legal Studies and Research. I remember I was the person who initiated this idea years back. I have been a part of this program for the last 15 years, 15 editions. Naturally, one may ask, do we need such a workshop on research methodology? As students of law, as lawyers, as law teachers, we all know the importance of research. And lawyers know that law consists of substantive law as well as procedural law. Procedure is as important as substance. So many constitutional concepts like due process, reasonableness, these are all very emphatic about the process, the procedure. And effective research also requires the correct procedure. Without the right procedure, you cannot travel smoothly. You'll never be able to reach your destination unless the path you choose is the right path. But I find that many students who are otherwise meritorious, brilliant, when they come for research, they go astray, they deviate from the right path. Very often because of the lack of proper guidance, the lack of proper understanding about the methodology they have to follow, essentially, to reach the right results, conclusions. So this 2-day workshop will just introduce you to the research methodology, the procedural part of legal research, nothing more than that. But those rudimentary ideas are very important, and to correctly follow the ideas that are passed on to you, transmitted to you in this workshop, I'm sure you'll become better researchers. And better quality of research will necessarily result in better law, a better legal system. In fact, it is absence of research which is a reason. Absence of research or the lack of quality in research. This is the real reason for any qualitative deterioration in our legal system. Very often laws are introduced for very noble purposes, having the welfare of society in mind. Many legislations are called welfare legislation, beneficial legislation, but ultimately they turn out to be anti-people, result in denial of rights for the people. Some months back, I saw a movie. It is produced in Tamil, but Malayalam version is also available, I think. JP, in which you clearly see the drawbacks of our legal system, the bias, the inbuilt bias that is operating in our legal system. How systematically justice is denied to the most vulnerable sections of the people. And 2 days back, I saw another Malayalam movie. The title is Pada, based on a real life incident. I very clearly remember that incident in 1996, when 4 persons, inspired by very noble ideals, their commitment to the cause of the tribal people in Kerala, they took the risk, calculated risk of entering the collectorate and keeping the collector as a hostage in order to press their demand that a law enacted by the Kerala Legislative Assembly, which will deprive Adivasi people of their land rights, this law should be withdrawn. That was their demand. They had nothing to achieve personally by taking this great risk, even risking their life. But it's because of such people that many noble causes have been brought to limelight. Remedies have been provided. So, but this film, incidentally, also draws our attention to the drawbacks of the lawmaking process. I don't know whether it is because of inadequate research, insufficient research, that such laws are happening. That's also one of the reasons, I can definitely say. So, one of the preliminary questions that arise when we think about legal research is, why do we need legal research at all? I'm not speaking about legal research which takes place as a part of, integral part of the curriculum, whether it is the bachelor's degree, LLB in law, or a master's degree in law, or a research degree in law, whatever be the stage. Within the academic institutions, research has a restricted meaning, serving only a restricted purpose. But research at a larger dimension. And our attempt should be to link our research, which is basically intended to be a part of our degree earning efforts. You need it because you want a degree. It's the bare minimum requirement that you have in mind. My idea of research is research as a process, all-embracing process. Research is not restricted to the curricular activities in an academic institution, but research which has to take place in government. Law reform. That's the primary objective of research. And our research, academic research, which is primarily for a degree, primarily as an integral part of your academic requirements, must also be linked to the larger process of research, which is essentially intended for law reform. You can never achieve reform in law unless you have the right research, the qualitatively sound research. So long as research inputs remain insufficient or weak, the quality of law will suffer. Some of the defects will be cured by interpretation, some of the defects will be made worse, enhanced by judicial interpretation. That's a different story. Now, development of law takes place through law reform, and law reform can take place only on the basis, with the support, on the sound foundation of legal research. That's the importance of legal research. Don't be under the impression that when you are writing a dissertation for your LLM, or you are doing a small project for your LLP, it is just an academic exercise. You earn a few marks in your examinations, or to satisfy the requirements of the university regarding the conferment of a degree. Yeah, they are there. I don't deny the existence of those. But more than that, if we are able to link our own small research to the larger process of research, it is possible. that we also contribute to the larger mission of law reform, improvement of our legal system. And the interest for research, the passion for research that is kindled in you as a student, if that passion survives, it can do wonders for our legal system. Now let me start with, see, my topic is an introductory topic where I will try to tell you how to identify a problem for research. That is first. And how do we write a synopsis? Synopsis, I would say, is a blueprint. You want to construct a building, you want a blueprint. An architect will draw a blueprint for you. Here, in research, you are the architect, you are the mason, you are the electrician, you are the plumber, everything. But nevertheless, the blueprint that you prepare at the beginning of your research, that's the plan according to which your research has to proceed, is very, very important. That's why I will tell you a few brief facts about a synopsis, requirements of a synopsis. Now, people usually start with the question, what is research? What does research mean? I don't want to burden you with a technical definition of research, but I want to tell you that research takes place everywhere. Everybody is a researcher. Don't think that only people who are educated, people who have taken degrees, people who have taken their postgraduate degrees, people who are aspiring to take a doctoral degree, these are the researchers. No. I will tell you, even a small child who cannot walk, who cannot utter a word, is a researcher. An illiterate person running a shop or doing odd jobs, he also does research in his own way. How does a child, a baby, becomes a researcher? Because a child, even as a baby, as a toddler, collects information, observes people, and this information is stored in her brain. And whenever required, that information is recalled, used. And then the child makes some classifications, some categorizations. What is good, what is bad? What does she like, what she doesn't like? So this is the starting point of research. Collecting information, storing information, retrieval of information whenever you need it, whenever it is necessary. And the data you have collected needs classification, categorization, analysis, and finally some value judgments in that also have to be made. Just as the child will have his own, her own idea of what is good, what is bad, the researcher should also have an idea, and in the process of research, these ideas get fortified, strengthened. So ultimately, after analyzing a particular decision of the Supreme Court of India, the researcher will say this particular decision is good for our society, for our system, for strengthening constitutional values. And the Supreme Court of India says the basic structure of the Constitution shall not be altered, abridged, even by a majority or even unanimously by Parliament. There are people who agree with the decision. There are people who disagree with the decision. As a researcher, you may also have to agree or disagree with the decision. But the researcher will agree or disagree with a particular decision of Supreme Court on the basis of reasons. There has to be a rationale for that conclusion. So how do you start that process? How you proceed with your inquiry? And finally, how do you reach a conclusion? How do you present your conclusions so that those who read your research report also get convinced of your arguments? So just as a lawyer tries to persuade a judge or a group of judges and tries to influence them to come to his own point of view, the researcher also is engaged in a persuasive exercise, the art of persuasion, the art of convincing people. Depending on the quality of your research, people get convinced about your conclusion, or they may still remain in doubt because you are not able to convince. Your arguments are not strong enough. Research may be defined as the act of searching. Search is there, even in the very word research. Research. So literally, we can say research is a search and search again and again. It's not a simple process, but it is a complex process where the search gets more and more complicated with each and every step you take. Research is the act of searching into a matter closely and carefully. It is an inquiry directed to the discovery of truth. So researcher has to be dispassionate, detached. You should not have any prejudice, any bias. Your own personal likes and dislikes, prejudices and predilections, all these are irrelevant. Our aim is to discover truth. And in particular, trained scientific investigation of the principles and facts of any subject based on original and first-hand study of authorities and or experiments. Experiments take place only in scientific research. When a scientist is engaged in research, it proceeds on the basis of experiments. We, legal researchers, cannot conduct any experiments. We cannot ask a person to kill somebody else and then study how that happens and what is his reaction afterwards, and then how the lawyer defends. We are observers. We cannot conduct experiments, but we can observe closely. We can draw lessons from our observations. We also use the authoritative materials of law, like legislation, judicial decisions, commission reports, committee reports, debates in parliament, debates in the legislative assembly, debates in the constituent assembly. So many valuable authoritative materials are available. And in addition to that, we also have the writings, juristic writings. People who have studied this problem earlier, drawn their own conclusions, inferences, which will inspire us. Sometimes we don't agree with them, sometimes we agree with them, whatever it is. Valuable lessons are conveyed to us by our predecessors. Now, what are the interesting observations on research made by Justice Frankfurter? Frankfurter was an American judge, and Frankfurter was an academician who became a judge, who was transformed to a judge. He was a professor of law. And for the professor's chair, he was directly elevated to the Supreme Court of America as a judge. And he's known as one of the best judges that the American Supreme Court has ever produced. Justice Frankfurt. Many of his judgments are simply famous. Many of his observations are quoted again and again, repeatedly quoted. And his observation about research is very interesting. Frankfurter says, research requires the poetic quality of imagination that sees significance and relation where others are indifferent, or find unrelatedness. So every research must have a poetic quality. A poet sees something which others don't see. Like any poem by any established poet, you find that the imagery, the ideas that you come across in the poem, they will be very simple, but immediately we think, oh, I didn't think of this when I saw the incident. One of our great Malayalam poets called Kumaran Ashan. Kumaran Ashan wrote a poem about a flower which has fallen down from a tree. Title of that poem is Veernapoor, fallen flower. And Kumaran Ashan says, Ha Pushpame, Athika Tunga Padattiletra, Chopichirin Vidur Rajni Kanakayeni. These are the words of Kumaran Ashan. He says, this flower was shining on the tree when it was on the tree. It looked like a queen, the majesty of a queen. But now it is fallen down. It's on the ground. We also see flowers falling down. But we never think of a queen fallen from grace, fallen from majesty, remaining on the ground. So this kind of vision, imagination, a poetic quality of imagination. You should be like a poet. You should be imaginative. A person without imagination can never aspire to be a good researcher. So a significance and relation which other people don't see. Unless the researcher can reach out to that significance and relation which other people don't see, you're not fit to be called a researcher. Then Frankfurter also says research requires the synthetic quality of fusing items. They are heretofore in isolation. So things which are remaining isolated are fused together by the researcher. Some logical connect, some synthetic relation is found out by the researcher, and it is revealed by the researcher in his research work. And above all, the prophetic quality. Researchers are prophets. Researchers are thinking about the future. So, a researcher, through his research, will establish the need for a new law or a new interpretation of the existing law, where he functions like a prophet. His words become prophetic. So, as Frankfurter says, researcher must have three qualities. One is the poetic quality. Second is the synthetic quality. And third is the prophetic quality. You are a poet, you are a synthesizer, and you are also a prophet. So don't think that the researcher's role is insignificant. The researcher's role is very, very significant as far as improvement of the legal system is concerned and law reform is concerned. Now, as students, we must have heard about doctrinal research and non-doctrinal research. Two, the broad divisions into which research is classified. As the words themselves imply, doctrinal research is based on doctrine, on theory. Doctrinal research organizes the research around legal propositions. As far as legal research is concerned, it is built around appellate court decisions and conventional legal materials. You don't do any field study of your own. This research takes place in the library. You sit in the library, make reading, you analyze problems, analyze critical issues, you analyze legal propositions and how they have been interpreted. Sometimes conflicting interpretations you may come across. So, doctrinal research is research around theoretical propositions. Whereas non-doctrinal research is not confined to doctrines alone, but the process of legal decision making. In doctrinal research, you read only the judgment. But on the same subject, if you are pursuing non-doctrinal research, you are also concerned about the process, the people, the institutions. Here, legal doctrine or legal theory, legal proposition is only one of the variables. For instance, you find out who are the judges behind this decision. To similar issues, what has been their attitude in earlier decisions. Whether you can identify a particular judge with a particular value, a particular ideology. So similar questions about the decision makers, the institutions in which they function, the institutional pressures. How independent is the judiciary, for example? What kind of appointment process will ensure independence of the judiciary? So many subordinate questions. And also, when your research is taking into account the impact of non-legal factors and events upon legal decisions, that also becomes non-doctrinal. See, so many factors will produce their impact, influence judicial, not only judicial, but decisions in the field of law. You're all familiar with the recent farmers' agitation. Some farm laws were introduced and amendments were introduced in some other farm laws. Widespread protests were organized throughout the country. And ultimately, the government had to withdraw these amendments and withdraw these farm laws. Here you find a non-legal factor, a non-legal influence on the process of legal decision making. Or some years back, there was a movement against corruption in the administration. There was a demand for enacting a Lokpal bill. This was a movement which finally resulted in the formation of Aam Aadmi Party. But the Lokpal bill, which was under the serious concern of the government, and bills were introduced from 1968 onwards in Parliament. But no Lokpal bill was ever enacted. Following this agitation, people's agitation, Lokpal bill was introduced, Lokpal bill was passed. But whether it was implemented effectively after that is a question I am not taking up now. Anyway, such movements which will influence lawmaking, that also could be a part of your research. When your research becomes something different from pure doctrinal research and it becomes empirical, non-doctrinal. So such result also has relevance. Such research also has great significance in our system. Similarly, an imaginative researcher can raise questions. Rather than analyzing the logical consistency, coherence of judicial decisions. Suppose you also raise questions about why this decision is like this, why this particular judge is always behaving like this, why this particular judge has a certain dislike for some values and an affinity for some other values. Some judges are very fond of right to property, while some other judges do not have that much affinity for right to property. They are more concerned about civil liberties, people's rights, rights of the poor, rights of the downtrodden. And then you may also think whether these value preferences have some nexus, some relation with the life experiences of that judge, the social background, the way in which he was practicing as a lawyer. So there's a very interesting book by an American judge, Cardoso. Actually, it is not a book. It is the text of 4 lectures that Justice Cardoso delivered to the students of the Yale Law School. Yale Law School, which is one of the topmost law schools in America. There, Justice Cardoso raises very important questions. And one basic question that he raises is, why do judges decide in a particular way? Suppose you give the same case to one judge. His decision will be different from the decision of another judge. You are giving the same facts, same documents, same arguments before Judge A. The decision of Justice A will be different from the decision of Justice B, who also has the same materials, same law is applied, same evidence is there, but why does the decision differ? So it is in that context that we may raise a question whether the socio-economic background of the judge is also a matter to be taken into consideration while analyzing judicial decisions. This is very important as far as the appointment process is concerned. What kind of an appointment process do we want? Who should be involved in that process? The United States, for example, the President of the United States can propose a name for appointment as Supreme Court judge, but he can only propose. It goes to the Senate Judiciary Committee, a committee of the legislature. This Senate Judiciary Committee announces the name or names. It's never kept secret as in our system. There's no confidentiality. There is transparency. There's openness about everything. A Senate Judiciary Committee conducts public hearings. Any citizen, any member of the public can appear before the committee, submit his views for or against that proposal. There are instances when, as a result of hearings before the Senate Judiciary Committee, information has come to light about the past incidents in the life of the proposed judge. And finally, Senate Judiciary Committee does not recommend his name, or it is put to vote in the Senate and rejected. So, such a transparent process. There was a case where one person's name was proposed by the President of the United States, and somebody appeared before the Senate Judiciary Committee and said, see, this man is unfit to be a judge of the American Supreme Court. Why? Because right to equality is one of the cardinal principles of our Constitution. This man doesn't believe in that. How do you know that? Then this witness says he has written articles, he has made speeches which reveal a clear racial prejudice in the mind of this judge. This not judge, this person is supposed to be a judge. Great prejudice against the black people. So with this inbuilt prejudice, if he becomes a judge of the American Supreme Court, it will be dangerous. He will subvert, undermine the value of equality, which is a cardinal principle, a cornerstone of the American Constitution. His nomination was not accepted. Do we have any such process? No. So these are matters which could be fertile grounds for a researcher to explore, where he travels beyond doctrinal research and embark on non-doctrinal empirical research. Okay. Now, let me put you another important question. How do we identify a problem for research? Very often, as teachers like me, who have been in this field for decades, many times confronted a situation where a student frantically comes to you, sir, please suggest a subject for my research. I used to say, you are unfit to do any research. If you cannot identify a subject, that means you cannot be a researcher. Don't ask for anybody's advice. Don't take subjects from any other person. He may be a competent person, experienced person, expert in the field. All that is true. But if you go in search of a subject to somebody else, that means you lack the primary quality to be a researcher. So, the first principle is the subject of research must come from your own heart. The brain also has a part in that, I don't deny that. But it must be your own brain, your own heart. You must have genuine involvement, interest in the subject you are going to do research on. Your involvement is 50% of your research. Suppose a subject is imposed on you by somebody else, whether it be a teacher or whether it be a senior student or a friend, whatever. Subject comes to you from somebody else, some external source, that means your involvement is not there. right from the start. So the first point that I want to make is, don't seek anybody's advice in using a subject, a topic for your research. You have to identify it. I will give you certain guidelines about identifying it immediately. But subject to that, it must be your subject. A subject which comes to you from your own internal thinking process. A jurist, Robert Merton, he has correctly said, it is more difficult to find and formulate a problem than to solve it. It is more difficult to find and formulate a problem than to solve it. Solving is easy. Finding a problem and formulating it correctly, this is more difficult. Once you formulate a problem correctly, identify a problem correctly, solution is easy. Half your problem is solved. Now, many people ask, people like you, many researchers come to us and ask, sir, this is a burning social problem. Can you do research on that? Some people may advise them. It may be a social problem, but it is not fit for legal research. In fact, my experience shows that every social problem has a legal dimension. Any social problem could be identified and taken for research by a legal researcher. You cannot make a watertight compartmentalization of social problems here and legal problems here. They are intertwined, inextricably intertwined. At some point of time, a social problem will become a legal problem. There is no problem which is purely legal. There is no problem which is purely social. But the question is, have you succeeded in identifying the social dimensions of the problem? As a legal researcher, did you confine yourself only to the legal aspects? A few minutes ago, I was mentioning a movie which was released last week, in which the land rights of the tribal people was the focus. And four young men forcibly entering the room of the collector and holding him hostage for about 12 hours. That was the theme of the movie. But here, the Adivasi land problem is a social problem as well as a legal problem. The Maoist movement, for example, it's a big problem in many Indian states. They challenge the authority of the state. Their means are violent, and they believe that only through violence certain problems could be solved. Do you think that their problems are just political problems? No. There are social and legal dimensions in all these. Freedom of speech, for example. So every legal problem definitely will have social dimensions, and but it doesn't mean that you are competent to deal with all these social problems which are related to legal problems. But you can definitely make an attempt. Now, whenever you are selecting a problem for research, two questions are relevant. One is a theoretical potential of that subject. By theoretical potential, I mean the capacity of that research to advance knowledge. You know, there is an existing pool of knowledge in every discipline, including law. And by your research, are you contributing a little bit to the advancement of the existing knowledge? Can you cause at least a little ripple? Because it is a stagnant, still water in a pool. You throw a small pebble into that pool. When that small pebble reaches the pool, small ripples are produced. But suppose it's a big stone that you throw, it will produce bigger ripples. So can you at least throw a small pebble? The existing knowledge is there as a stagnant pool. And can you disturb that pool a little bit? Will your research advance the existing knowledge? Not by leaps and bounds, but at least by an inch, a centimeter. Then, of course, what's the practical relevance of my research? Some research is, of course, very abstract, very theoretical, which may not have any significant practical impact, practical utility. But of course, some legal research which prima facie seems to be practically irrelevant will have long-term implications for advancement of the knowledge of law, advancement of new theoretical perspectives. So practical relevance is a consideration, but don't be discouraged by any lack of immediate practical relevance. Well and good. It's well and good if immediate practical relevance is there, but it's not a must. In every research, immediate practical relevance may not be there, but that is not a disqualification, a minus point as far as you are concerned. Now, you can also ask, is there any scope for further research? You find that on many or most of the topics, hundreds of persons have already done research. So many books, so many articles, so many things are there. Your duty as a researcher, is not to take something from some source, some other things from some other source, put them together. The information technology has done a great service to research, to learning, accumulation of knowledge. All that is true. But I would say it has also done some damage. Because you engage, a researcher engages only in a cut and paste method. Cut something from here, paste it here. Take something from there, paste it here. Like that. Your thinking process is never activated. You never do any thinking on your own. But there is also a danger in this method because plagiarism is very strictly, very strongly penalized now. I understand there is a separate session on that coming up. So instead of your own thought processes shaping your research, if you borrow from somebody, everything is borrowed, your research is practically worthless. No sensible person would call it a research. It is not research. So you should ask a question. What is the scope for research remaining in that subject? Can I do something new, something fresh? And what is that new thing that I will be able to do? What is fresh? What should be fresh in my research? Which differentiates it, which makes it different from all the other research done on the subject. So, this is very important. Can I do something different? Unless answer is yes, don't take up that research. If you cannot do anything new, leave it. Go to another subject. Then you should also ask some subsidiary questions. In what way the findings of my research will help? Will it clarify the law better? Will it result in resolving conflicts better? Will it be able to lay down new principles, doctrines, or rules? Will it help development of the law? Will it help law reform? Does this research has any social relevance? So, with the help of these questions, you can take a decision on the suitability of the subject, whether the subject is suitable for the research or not. Now, a very important thing that I must tell potential researchers about the choice of a subject, identification of a problem for research is take a small area for research. Do not have a big canvas and draw a blurred picture. Have a small canvas where you can draw a sharp picture, very sharp picture. The sharper it gets, the better it becomes. The quality of research always depends on the depth. And you can never go deep into any subject if it is very wide. One boy came to me some years back and said, I want to do research. So I asked him, what is the subject you have in mind? So immediately he answers, I will do research on fundamental rights. What an absurd answer, what an absurd approach. With this kind of idea, do you think that he will be able to do quality research? No, I have no doubt in my mind that he will be a total failure as a researcher, because he cannot identify a definite, precise area for his research. A person who says, I will do research on fundamental rights, is a person who has absolutely no idea about research. Even one particular fundamental right you cannot take for research. Suppose you just take right to equality or right to freedom of speech. Again, your research becomes very, very vast. It loses focus. Focus is very important. You take a photograph. Unless there's a focus, the photograph will be blurred. You may not even be able to identify who is in the photograph. So this sharpness, focus, this is very important in research, and it is a decisive factor in determining the quality of research. Now, how do you so along with that, along with identifying a subject which is sharp enough, precise enough. Another equally important factor is there, practical proposition is there, that you should consider the nature and availability of materials. Because I have seen many researchers coming after 1 year or 2 years after they start their research, coming to me and complaining, sir, sufficient materials are not available. So I asked them, are you understanding it only now? So a preliminary study to find out the nature and availability of materials is very, very important. What kind of materials will be available, from where these materials will be available. Now it is not a big problem. Even if comparative studies are envisaged, materials will come to you, no problem. Sitting on your table, sitting in your room, in your study room, you can have access to materials. See, when our generation was doing research, the American Supreme Court makes a decision. Sometimes we read it in newspapers. But the full judgment will be available to us maybe 1 year after that, or even more than 1 year. A journal which is published in America, like Harvard Law Review, a law journal, Columbia Law Review, it reaches India only 1 year after the date of publication. Even photocopiers were not available in my college days. Now all that has changed. With a click of the mouse, you can reach any journal anywhere in the world, any judicial decision anywhere in the world. You just type a subject. All the published materials on subject are enlisted, and then you can make a choice which one to download. So materials are available on any subject. And now I think the problem is not the lack of availability or scarcity of materials, but rather you are overloaded with materials, overburdened with materials. When you get a list of 80,438 articles on a particular topic, you type how to choose, how to make a rational choice from these 80,000 or 140,000 articles. So, rational choice of materials is now the problem. Limiting your search to absolutely relevant materials and absolutely relevant questions. That's the problem. And this overload of materials falling on your head will make you lose your focus, clarity. That should not happen. Now, how do you formulate a research proposal? You start with identification of subject. Then you have to give a proper title. And the title must truly reflect the subject. Must be a true reflection of your subject. Very often I have found researchers giving titles which do not have any relation with the subject, and sometimes we may not be able to understand the subject by reading the title. When you are giving a name to a child, you can give any name. So, Satyashilan. The പേര് കൊടുത്താൽ അവൻ സത്യം പറയുന്നവനായിരിക്കില്ല, അവൻ കള്ളം മാത്രമേ പറയുന്നുള്ളൂ. മീനാക്ഷി എന്ന് പേര് കൊടുത്താൽ the meaning, literal meaning of that word is you have eyes like a fish. ഉണ്ടക്കണ്ണിയായി മീനാക്ഷി, ശരിക്കുള്ള മീനാക്ഷി ആയിരിക്കില്ല. അവിടെ പേരും ആളുമായിട്ട് ഒരു ബന്ധവുമില്ല. The person as you see her or see him and the name and the impression you get from the name may be totally diametrically opposite to each other. But while giving a title to your thesis, the title should reflect the subject. എന്താണ് സബ്ജക്റ്റ് എന്നുള്ളത് വളരെ കൃത്യമായി പ്രതിഫലിപ്പിക്കുന്ന ഒരു ടൈറ്റിൽ കൊടുക്കണം. പിന്നെ framing of issues. What are the issues that I will take up in my research? What are the terms of inquiry? And it should have a hypothesis. Very often questions arise. Some time back, a senior teacher came to me and asked, "Sir, is it necessary to have a hypothesis as far as legal research is concerned?" Answer is yes and no. Both yes and no. Normally, yes, a hypothesis is necessary. And hypothesis is good for you. For your own sake, have a hypothesis. It gives more clarity to the main question that you are investigating. So let's have a hypothesis. What is hypothesis? It is a specific statement of prediction. Suppose your research is on capital punishment. What's your hypothesis? You can have different hypotheses depending on the focus of your research. Capital punishment is necessary for the prevention of crimes. That may be one hypothesis. Or another researcher may have a different hypothesis saying that capital punishment does not produce any impact on the incidence of crimes. Depending on the nature of your inquiry, you can select a hypothesis, but it must be a specific statement. It describes in concrete terms what do you expect will happen in your study. After the study, what is going to happen? So a prediction is made. Only after a preliminary study you can formulate a hypothesis. Hypothesis is a tentative explanation to the research problem, a possible outcome of the research, or an educated guess about the research outcome. It's an intelligent guess. A study may have more than one hypothesis, or no hypothesis at all. It is also possible. Don't worry too much about the hypothesis or the fact that you cannot formulate a hypothesis. But it is always better because your research, your inquiry will have a focus. You are searching for a definite answer to a definite problem. All that happens when you formulate a hypothesis initially in the synopsis. Then you must also formulate a few research questions. The questions you are trying to answer in your research, they must be spelled out and they must be specific. A research question can be made into a hypothesis by changing it into a statement. Question may be changed to a statement and then it becomes a hypothesis. And most important is, these may change over time as your research progresses. I have seen many researchers getting worried, getting frustrated when they find that more relevant research questions are there which they have left out. No problem. See, you are not very strictly confined to your synopsis. I would say it is better to remain confined to your synopsis, but when new questions arise, don't get panicky. Don't be frightened. This is the natural thing. This indicates that your research is proceeding on the right path. You are proceeding on the right path. Am I exceeding my time, organizers? Organizers are listening. Kavya,
Yes, sir.
am I exceeding my time?
So it's okay. I think we can wind up in a few minutes. It's okay.
Be more specific. When should I stop?
So we'll stop within 5 minutes.
Okay. The next session starts at
11:30.
yeah, we have time. Yes. Anyway, I will conclude. So, new questions emerging, new relevant questions emerging should not make you frantic. Don't panic about that. Even the hypothesis may change. No problem. These are all natural happenings, which very often show that you are proceeding in the right direction. So, new research questions emerging, or even a new hypothesis emerging in the process of your research is not a thing to be afraid of. Now, one more thing is, you must understand what is operationalization in your research. You formulate research questions, you formulate hypothesis. Very often these are very conceptual. Suppose your hypothesis has something to do with social justice, but social justice occurs. Now, unless you operationalize, you cannot proceed. What do you mean by social justice? So, you must reduce that concept. It is abstract. You must reduce that concept into definite variables, empirically ascertainable variables. Suppose your research on social justice has focused on preservation in government employment. Preservation in government employment. So you must be definite about when would you say that social justice is achieved in government employment? Can you rationalize that when the number of government employees is in direct proportion to the number of persons in population of a particular caste-based approach? So you can operationalize in that way, provided you can justify, you can provide rational justifications for your argument. If that is the best way to achieve social justice. Or in terms of opportunities. Or your research is on merit-based appointment or merit-based admission to educational institutions. Unless you give a meaning to the term merit. The research cannot move forward. The word merit is a neutral word. So giving meaning to words you use in formulating research problem, that is what we call operationalization. Because only by operationalization you can find out answers. You can raise relevant questions, definite questions. If you have read a recent judgment by the Supreme Court of India, the Supreme Court says merit must be viewed in it from a totally different perspective. Merit is not the marks you get in an examination. If an entrance test is conducted, you get 90 marks in the entrance test. Another person gets only 60. Another person gets only 40. It does not mean that the one who has secured 90% is the most meritorious person. For that, you must also analyze deeply the structure of the entrance examination. What are the reasons which place one person at the top of the list? Why does another person go to the bottom? So this is applicable even to university and school examinations. So Supreme Court very categorically said, we want a new definition of merit. We must have a relook at the concept of merit. So these things which occur in your research are very important and must be clearly understood at the beginning of your research. Then what does a 3-4 minutes more I need? Okay. What should be there in the synopsis? An introduction explaining the scope and relevance of the study, statement of the problem, hypothesis and questions to be investigated. How do you propose to investigate? That's the methodology. To what extent it is theoretical, doctrinal, to what extent it is empirical, non-doctrinal. Then it must contain a small review of literature. What has already appeared on the scene? How much the subject has been researched by previous researchers. Where you must explain how your study is going to be different from what has already been done. And finally, a chapter-wise breakup, which again I must tell you very emphatically that it is open to change. Don't think that because you have given 9 chapters, 1, 2, 3, 4, 5, 6, 7, 8, 9, you must always stick on to that. No, no such rigid requirement. You can revise your synopsis. You can change your chapter-wise breakup. All this is open to you. Then you must clearly have a clear idea about the sources. And since there may be other sessions which will explain these things, I wanted to tell you about plagiarism, but from the program, I find that another full session is devoted to plagiarism because it is assuming so much significance now. Now, these are the few introductory remarks that I wanted to make. And if time permits, you can ask a few questions. I will try to answer those questions. It depends. Yes.
So I will have a 5-minute short Q&A session. So if anyone have any queries, you may raise your hand in the Zoom app so that we can unmute you and then you can ask questions.
Good morning, sir. My name is
Morning.
Sarita. I'm a first-time LLM student, sir.
Yeah.
Should the hypothesis consist of an answer to the imagined question?
Yes, of course.
Okay, sir. Thank you, sir.
Now, next person.
Thank you, sir. Thank you very much for a wonderful lecture. And I have two questions. Number one, do you think social science is an integral part of law, or law is an integral part of social science? Number one. Number two, can we conduct any empirical research only on the basis of secondary data? Thank you.
You have raised two very important questions. To the first question, I have no doubt law is a part of social sciences. And there are many research areas in law where you can find out answers only on the basis of social science research methods. So it is very much a part of social science. Law is a part of social process, and legal research necessarily is a part of social science research process. Now, secondly, about empirical research and conclusions, drawing conclusions on the basis of secondary data. There are inherent dangers in drawing conclusions on the basis of secondary data alone. Drawing conclusions on the basis of data analysis itself is a very problematic area, because there, what are the variables you take into consideration is very, very important. And what are the value judgments which go as inputs in your decision making, conclusion, finding out conclusion, that's also very, very significant. So, for example, if you conduct a kind of field study on doctors and the curing of patients by each doctor. I remember one person doing an empirical study on doctors in Trivandrum, and ultimately one of the variables he used was that of caste. I don't know how caste is relevant in determining the curing capacity of a doctor, but finally this researcher came out with a conclusion that so many percentage of Muslim doctors cure their patients, so many percentage of a particular doctors belonging to a particular caste fail to cure their patients, like that. Absurd. But there it is your rational judgment on the variables you choose and the impact of these variables on behavioral patterns that determines the outcome. So there may be some situations when secondary data will be helpful, but I don't want to say that secondary data alone will justify any conclusion, because bias, the very beginning of the research may be biased. There are so many prejudices which may operate, which may influence, which may have an impact on the conclusion that you make. So it is very unwise. It is not advisable to arrive at conclusions purely based on secondary data. That is what my experience has taught me.
Thank you all. Now we are winding up the Q&A session. And Jayakumar sir, thank you so much for filling us with the awe and joy of your wisdom. Now I welcome Ms. Anjita, student of first sem LLM from Kerala Law Academy Law College, to give the word of thanks.
Thank you, Kavya. Good morning to all. It's my privilege to have been asked to propose a word of thanks for this workshop. I, on behalf of Kerala Law Academy and the entire fraternity of this college, first of all, extend my most sincere thanks to late Dr. N. Narayan Nair, founder of Kerala Law Academy. On my behalf, I extend a very hearty word of thanks to the chief guest, Professor Dr. N.K. Jayakumar, who spared time from his busy schedule to grace the occasion for the workshop. With his style and own idea of explanation of everything related to research methodology, I would like to express our profound gratitude to our principal, Professor Harindran K. of Kerala Law Academy, for his presence in this workshop. I am happy to express word of thanks to our professors, Professor Jayakumar K, Professor G. Anil Kumar, Professor Ajina Nair, Assistant Professor Dr. Dakshina Saraswati, all professors who made this seminar interesting and meaningful by the cooperation for this workshop. Event like this cannot happen overnight. So, as the wheels start rolling weeks ago and require planning and bird's eyes for detail, Here we are fortunate enough to be backed by a team of very dedicated and motivated team for our workshop, who know their task and are very much result oriented. I cannot thank everyone enough for the willingness and involvement to take on the competition of this work beyond their comfort zone. So I specifically thank the people who have been the backbone of this event, our technical arrangement team and students. So I once again want to state that we are grateful to the chief guest of this workshop. We thank you for being with us this time. Thank you very much.
Thank you, Anjita. With this, we conclude our first session of the 16th two-day National Workshop on Research Methodology. I extend my thanks to all those who made this discussion a fruitful one with your valuable contributions. I humbly request everyone to attend the second session of the workshop scheduled at 11:30 a.m. Thank you, everyone. This is K. Kapya Mohan signing off. Thank you.